Hello, everyone, and welcome to another employment law Q&A. My name is Alex Lucifero. I'm an employment lawyer and partner with Samfiru, Tumarkin, LLP. We are the employment lawyers. This is a live stream. This is a live Q&A. We are online right now and ready to take your questions, answer any and all questions that you have when it comes to your workplace, whatever the situation is that you're dealing with. If you've been let go from your job, certainly you need legal advice from an employment lawyer in those circumstances. But even if you're not dealing with a termination, maybe your employer is asking you to accept different terms of employment. Maybe they're changing your hours or your schedule. Maybe you're dealing with a difficult boss or manager and you're not sure what to do in the circumstances. You're worried you might get punished if you go to HR or if you raise your concerns. You have rights as an employee in those circumstances. You need advice, you need help to navigate through those tricky issues. Certainly, if you've been temporarily laid off from your employment, we'll talk tariffs in a sec, but I've already spoken to lots of people over the past several weeks dealing with the fallout of all of this tariff talk and all of the changes that are happening within lots of different industries. And unfortunately, what that means, what we're seeing is employers restructuring, employers downsizing, employers asking employees to change their employment. All of those situations trigger employment law protections for employees. Oftentimes, if we're talking severance, employees are going to be owed far more severance than what an employer initially offers them. And even if we're talking about changes to your employment, you have the right, remember, as an employee, to refuse significant changes to the terms of your employment. So if your boss is asking you to reduce your hours or accept a pay cut or change position, you don't have to say yes. You've got options in those circumstances. Make sure that you're receiving advice from an employment lawyer before you accept or decline any offers, any changes, anything significant that happens within your workplace. I'll give you another example. If you're being performance managed, maybe your boss or your employer comes to you and says, hey, we're putting you on a performance improvement plan, or hey, we don't like how you're performing, we're demoting you. All of these situations trigger employment law disputes, trigger situations where you need someone in your corner that has experience in those situations, that knows what employees can and can't do, and importantly, perhaps most importantly, know what employees should and shouldn't be doing in response to their employer making those kinds of changes, mistreating employees, or ultimately even terminating your employment as an employee. We're going to talk about all of this over the course of the next 25 minutes or so. Please, for those of you just tuning in, remember this is a live Q&A. If you're watching right now and you have a question about your workplace, again, you're dealing with a difficult boss, or you feel like you're being bullied at work, maybe you've been let go from your job, maybe you're on a medical leave of absence, maybe you're having health issues, you have to take some time off work to deal with those health issues, and your employer is giving you a hard time, or maybe even the insurance company you're dealing with is giving you a hard time. All of these are issues that we can talk about during this live Q&A. And I promise you, if you go ahead and ask your question, not only will you be helping yourself, I mean, you'll undoubtedly be helping yourself. I will answer your question. I will point you in the right direction in terms of the information that you need to know to resolve your workplace problem. I guarantee you as well, though, you're going to be helping dozens, if not hundreds of other people that are going to be watching this, that are dealing with this difficult situation as well, that are dealing with a similar situation. And your question, your situation will also help those people in their situations as well. There are a host of employment law issues that we see day in and day out, week in and week out, and we have lots of experience in these areas. So please go ahead and post your question if you're tuning in right now. It could be strictly confidential, right? Don't mention your employer. Don't give your full name. Keep it simple. Keep it brief. No one will know anything beyond that. And again, we'll get you on the road to resolving whatever workplace issue you have, or at the very least, just informing you on what your workplace rights are. And in these kinds of situations, the more knowledge you have as an employee about what your rights are, what your options are, the more power, the more authority, the more protection you will have in the workplace dealing with your employer. Wanted to talk tariffs a little. I see a lot of questions coming in, which is absolutely phenomenal. We might today head straight into the questions. Typically, I want to talk about a matter that's either in the news or a matter that's come across my desk either today or this week. But first, most importantly, I want to share our contact information. If you think your situation is complicated, maybe you're a little shy, maybe you're a little bashful, you don't want to ask your question online on a live stream, go ahead and contact us at the office. First place I'll tell you to go, employmentlawyer.ca is our website. Our website isn't there just for the sake of our contact information. Of course, it has our contact information. We've also, however, got a ton of resources on our website. Employment law essentials. We have a ton of articles. We have a ton of video and news clips. Really anything and everything under the sun dealing with employment law. You can find an article about it on our website. Just to get started, just for the basics, go ahead and visit the website, and it'll give you a sense of the situation that you're dealing with. And of course, again, it has our contact information. Speaking of contact information, do not be shy at all to send us an email as well. There is zero cost obligation. We have an entire team of intake people that are standing by to field emails and to field calls to our office. We'll share the number in a sec. help@employmentlawyer.ca is the email address. Go ahead and send us a brief email at that email address. Don't send us a 10-page letter. Give us a brief couple of paragraphs about the situation you're dealing with. Keep it brief. Give us the relevant information, right? And I guarantee you, someone will respond to that email. Someone will get back to you if you email us at help@employmentlawyer.ca. Again, we've got an entire team of intake staff, my colleagues, that are standing by, ready to field those emails and field those phone calls. And of course, if you want to kick it old school, you want to give us a call at the office, you can go ahead and visit our website. We've got a toll-free number as well, by the way, you can contact. But go ahead and give us a call. Again, we've got an entire team standing by to take those calls. And if we can't get to the call, leave us a detailed message, and I guarantee you, again, someone will get back to you. We pride ourselves in making sure we respond to inquiries and respond to them in a timely fashion. And we do the best we can in doing so. We take all of these emails and all of these calls extremely seriously. So again, don't be shy to reach out. We are here to help. We are here to help you resolve those workplace situations that you're dealing with. For those of you just tuning in, we're about 9 minutes in. My name is Alex Lucifero. I'm an employment lawyer with Samfiru, Tumarkin, LLP. We are the employment lawyers, particularly if you're in Canada and in the provinces of British Columbia, Alberta, or Ontario, and you're dealing with a situation at work, you don't know what to do, you're in a jam, maybe you've been let go from your job, whatever the situation is, you need someone in your corner to help you out. And that is what we are here to do. We are here to help you help guide you through, rather, the difficult, complicated, stressful situations that you can find yourself as an employee. We talked about a host of them a couple of minutes ago. Really, whatever the situation is, if you're feeling that stress at work, if you're feeling that pressure at work, that is a red flag. Do not just sit on your hands idly and have to deal with that stress constantly. Make sure you reach out to somebody that knows what they're talking about, that can help guide you through those situations. If you reach out to your HR department within your workplace, listen, I'm not saying that's a bad idea. Just know that a human resources department, a human resources employee, they are there, yes, partly to help you, but keep in mind, they're there mostly, if not almost entirely, to protect the company, to do the bidding of the company. And if that means that letting you go, or changing your employment, or demoting you, or laying you off is in the best interests of the company, your HR rep will put that on you, will force that upon you, and will ultimately even recommend that to you, potentially not in your best interest. Your HR representative is not someone that you can trust fully. They are there to protect the company, and they are working for the best interests of the company, not necessarily the employee. Guys, let's skip the case of the day or the situation that I typically talk about here to get us warmed up. I see a bunch of questions already, so let's get to them. And again, as I'm going through these questions, everyone, don't be shy to post yours. Make sure that for the rest of the segment, which is about 20 minutes or so, that we've got enough questions to inform people on what their rights are, to inform people on different employment law situations. So even if it's just for the sake of knowing, even if it's just for fun, so to speak, go ahead and post a question. I'll get to it. Even if it's a question about severance, quite simply, give me your age, your length of employment with the company, and your position within the company. I'll give you a sense of what your severance entitlements are. I mean, it's really that easy when we're talking about severance and employment law. Those are the three main factors that are taken into consideration: age, position, years of service. And so if you're just curious what your severance entitlements might be, go ahead and post those, right? And I'll be able to tell you. Again, don't tell me who your employer is. Just give me the basic stats, and I'll be able to tell you what your severance entitlements are, so that in the event that you're ever let go, you'll have at least a rough sense of what your severance entitlements are. And by the way, we've got a severance pay calculator that you can look up on online. Pocketemploymentlawyer.ca is the email address. And you could input, by the way, any situation that you're dealing with, really, and the Pocket Employment Lawyer will give you a sense of what your rights and what your options are in the circumstances, even when it comes to severance. By the way, there's a severance pay calculator, which we've had for many, many years now, built into the Pocket Employment Lawyer. All right, first in line for today is Friendly Fires on YouTube. Friendly Fires asks, if the government has made concessions for EI because of the issues with the tariffs, is it likely that they will change other employment laws to deal with the impact on Canadian businesses? Quite the technical question, Friendly Fires. What that person is referring to, by the way, is in Canada, because of all this tariff nonsense, if I could call it that, because of really just the state of the world economy and the tariffs that the U.S. has imposed, both on Canada in particular industries, mind you, but also across the world. Service Canada, the government of Canada, has made some changes to how employment insurance and severance basically interact. It was previously the case that when you were receiving a severance package, you would have to hold off on receiving EI. EI is employment insurance. So it's the amount that you receive from Service Canada if you're unemployed, and you've been paying into EI during your employment and you qualify, you'd receive EI benefits. Typically, it's like something like $500, $550 every 2 weeks if you've paid in and you've topped up to the max. Now, what the government is now saying is, well, actually, if you're receiving severance, you don't have to wait until that severance is up to start receiving EI, because that's how it worked before. You can receive both effectively. You could start receiving employment insurance right away, right? Even if you've received the severance package, even if you're receiving severance at the moment, so that you kind of are, you're kind of double benefiting there by receiving both employment insurance and severance for the same time period. Typically, that wouldn't be allowed. Service Canada wouldn't approve EI if you're still in a severance period or receiving severance, but they've since modified that because of the tariffs. Friendly Fires on YouTube asked, are there going to be any other employment law changes as a result of these tariffs? And I highly suspect that the answer is no. I don't think there are going to be any real employment law changes, keeping in mind, everyone, that certainly in Ontario, and I practice in Ontario, and if you're in Ontario and looking for employment law advice, you could certainly reach out to us at the office, but also I could provide specific advice with respect to Ontario employees. But this is probably generally true across Canada as well. Listen, our employment laws in Canada, at least, are actually quite protective of employees. I mean, certainly when it comes to severance, I mentioned severance being based on an employee's age, position, and years of service. So if your employment has been terminated, or if you've been temporarily laid off and you're pursuing severance, which you should, by the way, if you've been temporarily laid off, your severance entitlements are going to be significant, particularly given the state of the economy right now, but also just considering the tariffs, but also regardless of the tariffs. Severance is significant for employees, even if you're a short-term employee. I'll give you an example. A 1-year employee, you could have been with the company for 1 year and been let go from your job. You still may be looking at something like 3 to 6 months as your severance entitlements, not weeks, not days, months, 3 to 6 months of severance as a 1-year employee. That's how significant severance could be, even for short-term employees. And of course, if you're a longer-term employee, if you've been with a company 20 years, 20 plus years, even if you're in a specialized role or even in a management level role, listen, your severance entitlements could be as much as 24 months of pay. That's 2 years of pay. Again, for more senior employees, for longer term employees, that severance could be very, very significant. And so, to answer your question, friendly fires, those laws aren't changing. Those severance entitlements are staying the same. And the same would apply to any other area of employment law. Again, our laws are already quite protective of employees. And so you will have access to those rights and to those options as an employee if your job is impacted by the tariffs. I've said it already, and I'll say it again. The most important thing to note in those circumstances is that you've got to know what your rights are. If you don't know what your severance entitlements are, if you don't know that you can dispute a temporary layoff, or you can dispute a demotion, or dispute a change to your schedule, if you don't know that you have those rights as an employee, and by the way, you do have those rights, you are not going to know what options you have, and you'll just blindly accept what your employer is suggesting or what your employer has offered you as severance. Do not blindly accept anything that your employer is telling you. If you're not happy with it, make sure you receive advice from an employment lawyer first. Thanks for the question, Friendly Fires. Next up on Facebook is Terrence. Terrence asks, I'm an employee of a US company, but I live in Canada. They recently announced they're cutting their Canadian workforce, and none of us know what to expect. Will US employers still be required to pay severance? Absolutely, they will, Terrence, simply because your employer is based out of the United States. And quite frankly, Terrence, they could be based out of anywhere in the world. If you work in Canada and you live in Canada, guess what? You're a Canadian employee. Keep in mind, employment laws, at least for the most part, are provincially regulated. So it will depend, Terrence, on what province you are in. Although again, laws are generally the same across the country, but employment law is for the most part provincial. And so, for example, if you're in Ontario, I don't care that your company is out of the States. They're headquartered there. Maybe you're the only employee in Ontario, for example. We've had that happen lots. It doesn't matter. You're an Ontario employee. If you work and reside in Ontario, and you are going to be treated as such, your employer has to treat you as such, certainly when it comes to severance, but also when it comes to any other issue that you're dealing with at work. You have every right and every obligation, for that matter, that any other Ontario employee has, even if they're dealing with a made in Canada company with a based in Ontario company, for example. So certainly when it comes to severance, Terrence, we've said it a couple of times, I'll say it again, age, position, and years of service is the analysis. So it depends how long you've been working for the company, what your position is there, and your age as well, for that matter. Just as a quick aside here, speaking of severance, let's keep in mind the reason why the law looks at an employee's age, position, and years of service is because ultimately, the older you are, the longer you've been out of the job market, and the more senior or the more specialized, and therefore kind of the more rare your position is out there in the job market, the more difficult it's going to be for you to bounce back and find new employment. And ultimately, that is the purpose of severance. Severance is not meant to be a reward for good behavior. Severance is not meant to be some sort of punishment to the employer for letting you go. It's really meant to provide financial security to employees during a time where they're looking for a job. And so again, it's age, position, and years of service. And the older you are, the longer you've been with the same company, the more specialized or senior your position is, the more severance you're going to get. Even if your company, Terrence, is based out of the US, those rules do not change one red cent. That is the way your employer is going to have to pay you severance. And that's that, tariffs or no tariffs. All right. Next up is Earmail. Earmail asks, I have an IME on May 10th. For those of you that don't know, an IME is an independent medical examination. Can I go back, modify duty before the IME, meaning go back to work? My long term disability application was submitted 2 years ago, and my lawyer seems to agree with me. Resign. Is this going to hurt my LTD application? So this is a long-term disability insurance a question, by the way, related to employment law certainly, but we have an entire team of lawyers that deal specifically with long-term disability benefits being denied by insurance company. It's something that happens, unfortunately, extremely often. Insurance companies, I hate to say it, I say it begrudgingly, they are in the business of denying long-term disability claims. If you are dealing with a medical issue at work and you have to take a leave of absence and you apply for LTD, there is certainly a chance, and probably a significant enough chance, that your disability benefits application will be denied for one reason or another. Do not accept that denial as gospel. If you've been denied even short-term disability benefits for that matter, but whether it's short-term or long-term disability benefits, if you've been denied those benefits by an insurance company, you've received a letter from the insurance company saying, no, we're not paying you while you're off on medical leave. Again, don't just sit there and do nothing. Give us a call at the office, reach out to us. Let's have a chat off air. Let's get into the details. If your doctor supports you on being off on medical leave and supports your long-term disability application, there is no reason why an insurance company should be denying benefits. If you want to know more about this subject, disabilityrights.ca is the website to go visit. You see it on the screen right now. Don't be shy. Again, give us a call at the office, send us an email, visit the website if you have disability benefits issues. It's something that we pride ourselves on helping employees with as well. Now, Irmel, to answer your question, and I kind of alluded to it already, but the answer is quite simple. You've got to follow your doctor's lead, right? Regardless of the IME or not, if you've been on medical leave for 2 years now and you've been unable to work, and just now you're able to go back on modified duties, and again, most importantly, your doctor supports that position, right? Then I see no problem with it. It will obviously affect your current disability claim, right? In the sense that, well, if you're able to work starting now, it's possible that you will not be owed any future disability insurance benefits, right? Or perhaps there will be a set off there based on how many hours a week you can work, for example. But it certainly shouldn't affect any benefits that you are owed retroactively, meaning into the past. I would not do anything Earmail without your doctor's support and approval and authority. Keep in mind, in these disability insurance benefits cases, you have to be in line with your doctor. You have to follow your doctor's advice. And ultimately, it is your doctor's opinion that matters. It's not your personal opinion about whether you can work or not work or how much or not. It's your doctor putting in writing saying, yes, he can go back on modified duties, or no, he can't go back on modified duties. And I would follow your doctor's lead in that respect. That shouldn't affect any past benefits that you would be owed if you were previously unable to work completely, but it may affect future benefits if you go back to work, of course. I'm sure you realize that as well. Hopefully that helps. If you want a second opinion, it sounds like you have a lawyer already, but if you want a second opinion, if you're not sure what to do, again, give us a call at the office, send us an email. Happy to chat with you off live stream about this situation. Keep in mind, the devil's always in the details. So it's always important to have a lengthy, detailed conversation where we can go back and forth, ask a ton of questions, make sure we understand your situation from every angle in order to properly advise you. That's why these kinds of conversations are so important. Next up is Gladys. Gladys asks, daughter works for a US-based software company. She's in Ontario. They're taking away work from Canadian staff. She's worried about the whole division being cut. What should she do? Gladys, great question. With respect to the work being taken away, it is a question of degree. So if it's a task or two, and otherwise your daughter's schedule is kind of unaffected, I mean, she might have a couple of less things to do, but she could still fill a 40-hour work week, for example, right? Then, there shouldn't be too much concern there. If, however, they are taking away a significant amount of her job responsibilities and duties, And I don't know how, if she's being paid a salary, then maybe her pay is unaffected. But if the removal of job responsibilities and work is starting to then affect her pay, perhaps, if she's on commissions or where sales or whatever the case may be, and that's starting to have an impact on her earnings, that is a major red flag. Any significant change in that sense, Gladys, should be a red flag. That could be what's called a constructive dismissal. And I'll go back to what I've said it already. A major change to an employee's terms of employment gives an employee the right to refuse those changes and to say no. And if the employer insists, it may then give that employee the option of claiming severance. And if you're starting to feel, or your daughter Gladys is starting to feel, that this is a bit of a sinking ship, right? Maybe thinking about severance and how much severance she might be owed if she's let go, or how much severance she would be owed if there's a major change to her employment. Just starting to maybe plan in that respect would be a good idea. Ultimately, if you're looking, if you're thinking severance, or if you're thinking protecting your employment rights, you don't want to necessarily just out and out resign your employment. You may ultimately even want the employer to make the final decision to let you go. There's nothing wrong with that. People think that there's lots of stigma involved in a termination of employment, that it goes on some sort of permanent record. It doesn't. Almost always, it's better for the employer to make that move to terminate employment rather than the employee suggesting severance or asking for severance. That does not make sense. An employee has no leverage in those kinds of situations. So, Gladys, I would tell your daughter, be mindful of any major changes to her employment. Again, if it's just one or two tasks, let it be. If it's more than that, tell her to reach out. Let's have a conversation off air and figure out how to manage that situation. Should she be engaging right away with her employer, or should she just kind of get some basics in terms of her severance entitlements, in terms of when she should be drawing that, or where rather she should be drawing that line or not, just so she's armed with that knowledge and that information about what to do if it happens. Email asks, following up, can an email sue their employee if they are unionized? They cannot, Irma. They can certainly file a grievance through their union, but they cannot sue their employer themselves. Keep in mind, unionized employees, the rules of the game are different. If you're a unionized employee, your terms of employment are governed by a collective agreement. A collective agreement is basically a contract between a union and the employer, and it is the rules of that collective agreement that govern the union's employment and the individuals in those unionized employees, their employment within the union. And if you have a problem with the employer as a unionized employee, your sole legal representative, the only entity that can help you resolve your workplace issue and represent you when it comes to a workplace issue, is your union and your union rep. If you're a unionized employee and you're dealing with an issue at work, go to your union rep right away. Unfortunately, those unionized employees, they can't see an employment lawyer. At least 99% of the time they can't, because again, it's their union that's their legal representative. Couple of minutes left, guys, so we'll do a bit of a rapid fire here. I want to make sure I get to all of your questions. Next up is Lisa. Lisa asks, I'm being treated for PTSD due to a major accident at work 4 years ago. Should I apply for company LTD, or can I go to WSIB? If it is a workplace incident, Lisa, it would be a WSIB claim. I'm a little worried if you're saying now that this was 4 years ago. If you haven't applied already, you certainly should. Your employer, by the way, should be playing ball in that respect as well. Now, mind you, maybe the PSD is more recent. So maybe this is more recent than just 4 years ago, but it would be a WSIB claim if it is a workplace incident. Keep in mind, WSIB is an insurance company as well. It's the same process as dealing with a private insurance company, right? Make sure you've got your doctor's support. It's your doctor's opinion that matters, right? And ultimately, if you are denied the WSIB benefits, then there is an appeal process. There are lawyers that can deal with those kinds of things. Harry is up next. Harry asks, if you are working on annually renewed contracts and the employer opts not to renew for the next round, what rights do you have? Harry, phenomenal question. If these have been year in, year out contracts for a certain period of time, I'll just pick a random number and say 3 years, right? It could be three or more years, certainly, right? If you've signed contracts year in and year out, and you were really kind of expecting to sign another one this year, but you've since been advised that it's not going to happen, guess what? You're a 3-year employee. I'm using an example here, but all of those years of service will count, and you will be owed severance based on those full years of service. Rolling yearly contracts like that do not protect an employer in the way that an employer might think it does. At the end of the day, those employees are still owed severance, and they're owed severance based on the entire length of service, all of the contracts combined, not just the latest 1-year contract. Let's keep going if that's all right with everyone. Appreciate everyone tuning in. Let's answer these last couple of questions. Henry asks, my sister has finished up her parental leave and her employer has gone quiet. Not a good situation for the employer. They aren't responding or giving her a return date. What can she do? I thought her position was guaranteed. Henry, you're absolutely right. It is guaranteed. The employer has an obligation to return her back to work. Even if, for example, her position doesn't exist, maybe it's been eliminated, maybe it's been restructured, they have the right, or sorry, they have the obligation, the employer that is, has the obligation to return your sister back to a position that's comparable. If they've gone quiet, it's a major red flag. I would tell your sister, give them one more chance. Give them 48 hours to respond to an email. Be polite, to be clear. Be professional. Don't get nasty, but be stern that you absolutely need a response within 48 hours. If they don't respond, reach out to an employment lawyer. Give us a call at the office. We can get involved and solve that situation pretty darn easily. Employers have to return employees, or have a darn good reason if they're not returning an employee back from a parental leave or a maternity leave. And if they don't return them, then that employee is going to be owed severance, and it's going to be significant for sure. All right. 2 last questions, everyone. Renee asks, what keeps a company from refusing to pay proper severance and ignoring an employment lawyer to drag out the process as long as possible, relying on former employees' duty to mitigate? Renee, it's a good question. Listen, there are lots of reasonable employers out there that with some gentle pushing, will pay the correct amount of severance, will honor their legal obligations. And that's that. A lot of times when we're dealing with a severance issue, when we're negotiating severance, it is not complicated, it is not difficult, it does not take time. However, it sounds, Renee, like you might be dealing with, and there are exceptions to the rule. There are some employers out there that are cheap, if I'm putting it frankly, that refuse to honor their obligations legally, and that will draw out these processes as long as possible. Renee, what I will say to that is what our court system and the legal system is for, is to hold those employers to account. Doesn't necessarily mean in those situations that it's going to be quick or easy necessarily. Again, in most cases it is, but in those exceptional situations where an employer is refusing to be reasonable and being cheap and being difficult, that's what our legal system is for. And I will guarantee you, Renee, ultimately those employers end up paying for it. They do end up paying the price for being unreasonable. Don't give up just because you're dealing with a stubborn employer. Make sure you have the right person in your corner representing you. Last question, folks. Thank you all for these excellent questions today. Really productive live Q&A. Alicia, to close us off tonight, or this afternoon rather, not tonight. Alicia asks, can an independent contractor terminated unfairly be reporting unethical conduct to the board of management, get severance benefits? Alicia, the answer to that question is really a different question. The question is whether truly you are an independent contractor or not. Oftentimes, we will see employees being called independent contractors. They're paid and treated as independent contractors. But when we dig under the surface, right, we actually see that they're employees. They work only for one company. They're paid regularly. They use company equipment. They hold themselves out as representatives of the company, despite whatever contract they may have signed, despite what they call themselves or even how they're taxed. If that independent contractor is truly an employee, absolutely they're going to be owed severance, right? And they're going to be owed severance like any other employee would based on their age, position, and years of service. Thank you again, everybody, for tuning in. Excellent questions today. I hope I answered them all. And if I didn't get to them, tune in to our next live Q&A. I think we've got one tomorrow as well. And if you have any lingering issues or questions, don't be shy to reach out to us at the office. You know our contact information. Until next time, everyone, it's been a pleasure. Have yourselves a great rest of the day.